on to the last document, which is the simple will. The simple will is called that because it is extremely simple. And so I would use this as a starting point. Part of what we do in my job with the contracting with the Department of Health and Human Services is we do document clinics for low-income elderly people around the state who don't have any of these estate planning documents, and all they really want to do is give away their, make sure that the right person gets their china collection and somebody takes care of their pets, and maybe they have a car. And so this is a very, very simple will to do very simple things like that. And there's a number of things that we have put into this document. Because we use it for document clinics, there's a nomination of a guardian, there's methods of distributions to minors. So obviously some of this language will not apply to every client, so we'll just delete out paragraphs if they're not necessary. I make changes to every time I use this document. I make significant changes. I definitely don't recommend using this as just a fill in the blank kind of form to give a client who doesn't have the money to pay an attorney. It's a good starting point. It's a good starting point to think about what your client's going to want and need and what should go into a will. One good thing that's provided in Montana about laws is called a personal property list. And so someone can complete a will and then just attach a personal property list to be completed at a later date. So any personal property that they put on that list, for instance, the car and the furniture and the coin collection and the gun collection, they can decide who's going to get that property and put it on the list. And they can change their mind and change the list or add to the list or subtract to the list. And as long as it's with the will when they pass away, that list is a very easy and convenient way to deal with personal property, rather than actually having to list every single thing in the will and then having to change the will or do a new will or file a codicil to the will anytime they change their mind or they sell their coin collection or whatever. A lot of people think that they file their will down at the courthouse, and as far as I know, there are no county courthouses that still accept wills. There might be some small town somewhere that still does, but that used to be a common practice, at least in Montana. You would complete your will and take it down to the courthouse and file it, and then everybody knew where it was when you passed away. Great system, except for the fact that it filled up the courthouses, and for obvious reasons, the court clerks didn't want to deal with it anymore. So as far as I know, no courts still accept the simple will. So what I recommend, and I should have said this with every single document that we've gone through, I recommend that any original important document be kept in the same place and be kept in a safe place. And that safe place should not be a safe deposit box down at the bank, because frequently that's impossible to get into after someone has passed away. So it should be in a safe, the original should be in a safe place with all of your other important documents, including your powers of attorney and living wills and everything else. And everybody else should get a copy. It is incredibly common for at least the clientele that I've run into is that this is a chore that they had to go through. They've ticked off the boxes on all these documents and they stick them in the drawer, and that's the end of that. And as you might imagine, huge problems arise when families discover, either when someone's become incapacitated or when they've passed away, that so-and-so is inheriting this property, or so-and-so was appointed as the power of attorney, or so-and-so did a living will. And it can really create a lot of family angst and difficulty, and even lead to court action. So what I recommend is when somebody makes these important decisions, end-of-life planning and estate planning documents, that everybody important to them should know about it. And by everybody, I obviously mean close family. I also recommend extended family. If you have a lawyer, your lawyer should have a copy. If you have an investment advisor, your Edward Jones person should have a copy. If you have a regular doctor or a regular hospital healthcare provider, they should have copies of these documents. Everybody should know even though they might not agree, even though there might be family difficulties. Everybody should know ahead of time, because now is the time to iron those wrinkles out rather than after someone's become incapacitated, or rather after someone's passed away. One more quick story, and then maybe we'll have a few minutes for question and answer. Most people have probably heard about a holographic will. Montana does recognize holographic wills, and as you probably already know, that's just a fancy word for a handwritten will. If someone writes a will in their own writing and signs it, that's a perfectly legal will. It doesn't have to be notarized. It doesn't have to be in the right form. It doesn't have to say last will and testament. And my favorite example of a holographic will, and this actually happened up in Canada, is that a gentleman, a farmer with a large farm in a large estate, did not have a will. And he was getting older, but he was by no means elderly, and he was out in the field far away from the homestead driving his tractor, and his tractor went into a rut, tractor turned over and fell on him. He was pinned under the tractor and bleeding, and this was before cell phones, and there's nobody to call, nobody can hear him, and he knows he's going to die. Well, he got the screwdriver or awl out of his pocket, and he scratched into the fender of that tractor that he wanted all of his property and all of his estate to go to his youngest son. And then he died. And I don't know how long it took to find him, but when they found him, they found the fender on that tractor. And other than the youngest son, you can understand that the rest of the family was fairly upset about whether this was an enforceable will or not. Well, it went all the way up to the highest court of Canada, and the answer is yes, that's a perfectly good holographic will, and so the youngest son got the estate. And someday I'm going to take a road trip to Saskatchewan. There's the School of Law there has that tractor fender on display in their law library. Unfortunately, I think it's about a 3-day drive from here, so maybe I'll get around to it this summer. Again, this was a brief, basic introduction to basic estate planning documents. I hope it was helpful. I know those resources I gave you will be helpful. So good luck in the future, and I'd be happy to answer any questions if we have them.
Okay, great. Thanks for your